Hey, everybody. So, yes, I have great news regarding the YSL trial and Jeffrey Williams, most specifically the fact that we know that Fani Willis and her merry band of prosecutors not only failed miserably with regard to the criminal case, but it looks like they have been dealt a pretty serious, potentially fatal blow regarding trying to seize his assets. So, if you remember, in addition to the criminal case that was proceeding, they had seized about $150,000 in cash, a bunch of jewelry. There was a missing watch, if we remember, that as far as I know still hasn't been found, and a bunch of cars, among other things. Now, the way civil forfeiture works is, you get the initial notice that the stuff is being seized. There's traditionally a discovery process where the parties then exchange information. The government gives them their stuff on why we think this is, the ill-gotten booty that we get to keep, and the defense can, respond with their own information. And then the statute says they are supposed to have a hearing within 60 days. Of course, the YSL trial was a unique situation. So what happened when the DA's office initially filed this was the judge said, look, we'll give you 90 days for discovery, and then I'm going to put a stay, meaning a pause, on this civil forfeiture proceeding while we let the YSL criminal trial work its way through the system. And that's exactly what happened. We know it went on for forever and a day, resulting in a set of fabulous, spectacular level failures by the district attorney's office. But in the end, it has gotten resolved. The very last outstanding defendant had his case resolved. And so on April 1, Paige Whitaker lifted the stay on the civil forfeiture case, which means now the clock is running again. Well, here's where it gets interesting. Brian Steele, who is Young Thug's attorney, said he never got notice of the fact that the stay had been lifted on April 1. And he's got some pretty clear evidence that he was never given notice of it. During that same time, though, the judge did reach out and say, hey, we want to get this scheduled, which if I were Brian Steele and I didn't know that, the stay had been lifted, I'd probably assume she's going to go ahead and get the hearing scheduled and then lift the stay. So he responded and said, look, I'm in trial. I've got a conflict at the end of April, early May, which of course he did because he was lead counsel in the Diddy trial at that time. And so they went back and forth via emails with the Fulton County DA's office and Judge Whitaker's office as well. Everything's attached to this motion. And if you go to Fox 5, they have the article from yesterday, and they've got these pleadings on there, and you can read them. So anyway, he's just saying, look, I can't be there end of April, early May, because he's in this trial. That's not asking for a continuance. That's him saying, I have a conflict. I literally cannot be in two places at once. And when lawyers have those conflicts, they have particular rules that they have to follow in what order they appear somewhere. And the judges know that. So the judge said, all right, well, let's see if we can pick some other dates. Brian Steele didn't say anything because, again, he didn't know that the clock was ticking. So they go back and forth, and eventually they agree on this August 18th and 19th date to have this civil forfeiture hearing. Well, fast forward now to somewhere August 12th. He finds out, wait a minute, this stay has been lifted since April 1. Well, that means the state had to get this done either in the month of April or the month of May. And we are way past that now. So you have to dismiss it. Of course, the state blows their top and says, no, you can't do that. You agreed to this August date. You asked for continuance, which I don't really think he did. He had a conflict, and he actually gave multiple other dates. Now, whether he could have been heard in May, later in May, I don't know. But that is a responsibility of the state to get that scheduled. It is no way a responsibility of the defense to get it scheduled. So needless to say, now Judge Whitaker is trying to decide, can we proceed on August 18th or not? And she read the case law, and the case law is very strict against the state because, theoretically speaking, the law does not like it when people get their property forfeited. Of course, it still happens all the time. But what this means now is that Paige Whitaker had to make a decision, and she said, nope, I'm dismissing it. You had 60 days. That's what the statute says. I don't have a choice. I got to dismiss this. The state issued a press release afterwards, basically saying they're considering an appeal, and we'll have to see whether they can get the Court of Appeals to hear that. But even if the Court of Appeals ruled in their favor, all that does is give back that time for them to schedule the hearing. That doesn't mean that they're still going to be able to keep Thug's property. And I mean, I don't know Paige Whitaker, but man, if I were her, I would be so sick of the Fulton County District Attorney's Office at this point and anything having to do with YSL. I can't imagine that they're going to have an easy time trying to seize thugs' property permanently. You'll also know, because we have brought this up in the past, that Fani Willis paid her boyfriend, Nathan Wade, during the YSL criminal portion through funds seized by civil forfeiture. Now, it wasn't the exact same money. I think some people got confused by that. But there is always the open wondering that you rob Peter now to pay Paul, almost literally, and whether she was very hopeful going into paying her boyfriend out of the civil forfeiture fund that they were going to see a big windfall from Young Thug's property, because the timing of when they first seized Thug's property to when they first paid Nathan Wade out of that forfeiture fund was only a matter of weeks. So not a good day yesterday for Fani Willis overall, but let me throw up a big red flag and have everybody within earshot of me pay attention. Civil forfeiture is a very easy way, in a lot of cases, unfortunately, for the DAs to get money. A lot of people don't know how to defend civil forfeiture. The timeframes are very short. So 1 minute they've seized, your rent money or your car, and before you know it, they're keeping it. And I know for a fact that there are multiple district attorney's office very close to Atlanta, one in particular that I'm thinking of, that's desperate for money. And one quick way to get money is through civil forfeiture. So we as citizens, and we especially as defense attorneys, have to be very, very aware of some attempts at property and money grabs that may be coming around the corner. Because again, when you're desperate for money, maybe for a legitimate reason, maybe because you want to, pay your friends to have cushy jobs, that's one way to get it. So let's be careful out there, and I will keep you updated.